पीयूष जी हैं.
So live streaming शुरू हो गई है, so we'll start the program.
Okay.
So thank you very much everyone for joining today's event of Friends of India Society International. Today's topic is very hot topic in today's day, judicial reforms and the way forward. As you may be hearing, a lot of things are going on in the public domain by the Law Minister Kiran Rijiju about the collegium and so many other incidents which are happening currently. So on this topic, we have our own Dr. Adityanji to speak and lead the discussion. But before that, I would request our International President, Dr. Agnihotriji, to say something.
Very nice. I think it's a very, very, very good topic and timely topic. And I requested Adityanji to lead the discussion. I personally know a lot of things about this whole issue because when I was not high-time judge, but I was a judge at that time in India, and I had the opportunity to meet some of the people at the highest level, and I could figure out what they were talking about mostly. One person, for example, who was the Supreme Court judge, I won't mention names, and I don't want to give you the timetable. So I had gone to see him for some reason, and then there was a son, and he was studying somewhere law. And in a way, he mentioned to me that ultimately he will end up being where his father is. And he did. I know the history of the whole thing, but I don't want to say that this time. And I know that Adityanji has done a wonderful job in studying, and he has, so there are a lot of things to talk about. And when maybe I'll talk to you folks later on sometime, because I have a lot of things to talk about. Because when I left the judgeship and came to America, even at that time, I was in touch with some of these people, and I could see that how they were working as a family, that your son will become my son will become yours, that kind of stuff. It was not all the time, not always about everybody, but they had managed to see that their people are fixed properly. It was unfortunate, but that was true. And I mentioned this to one of the Supreme Court judges, who was, I don't want to mention his name also, who had to hide almost when there was some sort of problems in India, hide almost, and asked me to go from the back door. But anyway, we'll talk later on some other time. Okay, please start the process. Okay, thank you.
So I'll go ahead and start. First, my thanks to Bhishmji for inviting me to give a talk and then lead the discussion. One disclaimer, I'm not an advocate, I'm not a legal scholar, I'm not a constitutional scholar, but I'm a student of public policy and public events going on in India. So I will try to be as objective as possible. And I have slides, so I'll go through that PowerPoint. So we will look into the broader issue rather than just a conflict, judicial reforms and the way forward. And of course, that's the flag of India, and that's the temple of justice. So those of you who saw this announcement, basically we started about rejection of NJAC, constitutional amendment, in 2015 by the Supreme Court. Supreme Court did not let this National Judicial Appointment Commission Act to be operative even for a single day. You know, you may say something is defective after trying it out. But despite Parliament passing constitutional amendment, both the chambers, President signing it, 21 states ratifying it, it was not allowed to be implemented for a single day. Because Supreme Court wanted to continue what they call is the collegium system. And there's a lot of critique of that system, and there are charges of nepotism and favoritism by general public, but also by brother judges from the Supreme Court itself. And there are two names that have gone on record: Justice Rama Paul and Justice Chalameshwar. In last 2-3 years, there have been exchanges between Supreme Court and executive and Supreme Court and the legislature. And it is leading to a very conflictual situation, which is not good for any branch of the state, whether that is legislature, judiciary, or executive, or for the nation itself. So I'm going to review some of the material from the beginning, taking a very factual historical approach. So how did the Constitution of India came about? A Constitution Assembly was appointed. Mind you, it was not directly elected. It was indirectly elected in 1946 when India was not even independent. They were indirectly elected by provincial assemblies, by the princely states, and by the British-controlled states. And it had a total of 389 members. And when transfer of power happened and country was carved out, the number came down to 299. So some of the people who were members of the Constitutional Assembly later on went to Pakistan. So we have to keep that in mind. Constitution Assembly had a drafting committee. Chair of Constitution Assembly was Dr. Rajendra Prasad, and chairperson of the drafting committee was Bhimrao Ambedkar. They had 11 sessions, sat for a total of 166 days. November 26, 1949, Constituent Assembly adopted the Constitution of India, which came into force on January 26, 1950. So Constitution of India, Article 124 says, Chief Justice of India and the other judges of the Supreme Court are appointed by the President under Clause 2 of Article 124 of the Constitution. It is mentioned in the Article 124 that the appointment by the President is to be done after consultation with the judges of the Supreme Court as the President may deem necessary. So the appointing authority per Constitution is the President of India. It is not the Chief Justice of India. And if you look at the Article 124, says establishment and constitution of Supreme Court, there shall be a Supreme Court of India constituting a Chief Justice of India, and until Parliament by law prescribes larger number, not more than 7 other judges. Today there are 34 judges, and every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation, not concurrence, with such of the judges of the Supreme Court and of the high courts in states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65, provided that in case of appointment of a judge other than the Chief Justice, the Chief Justice of India shall be consulted. A judge may, by writing under his hand, address to the President, may resign his office. So that's how the process is. However, what happened that by a series of judgments, the power of appointment to the judiciary was taken away from the head of the executive branch, which is actually, or head of the state, which is a president, to head of judiciary, which is Chief Justice. And there were some initial judgments of the Supreme Court. First judgment was Golaknath case versus State of Punjab. This judgment reversed Supreme Court's earlier decision, which had upheld the right of the sovereign parliament to amend all the parts of Constitution, including Part 3 related to fundamental rights. So Golaknath case judgment left the parliament with no authority to curtail the fundamental rights. And in writing this judgment, the Chief Justice K. Subbarao first invoked the doctrine of prospective overruling, which he imported from United States law, saying that, if there is a ruling that can overrule previous all amendments and laws. Then there were 3 judges' cases. First one was S.P. Gupta versus Union of India in 1981, also known as Judges Transfer Case. Supreme Court Advocates on Record, 1993, and a special reference of 1998. The outcome of these 3 judgments was that the court evolved the principle of independence to mean that no other branch of the state, including legislature and the executive, would have any say in the appointment of judges. The court created the collegium system, which has been used since the second judge case that was given in 1993. Mind you, the Constitution of India does not mention the word collegium, either in the original Constitution that was adopted or in any of the amendments that were passed to the Constitution. So collegium system is not based on Constitution or subsequent amendments, but by Supreme Court's own observations. And this has led to, over a period of time, conflict between the judicial branch of the government and executive branch of the government. What has happened that judiciary has systematically encroached on the domain of the executive. Using the tool of PIL, public interest litigation, judiciary wants to make all the policy decisions, which should be the domain of the executive. In more recent years, all the major decisions taken by the executive, demonetization policy, purchase of Rafales, farmers' agitation, law and order situation like Shaheen Bagh blockade of roads. In everywhere, judiciary has interfered and decided to opine whether it was required or not. And because of this judicial interference, you have seen instances of wanton lawlessness in the capital of India, when government or the executive's hands are tied because Supreme Court will not let them function. It has come to this extent that Supreme Court is interfering in the armed forces of the country, their effectiveness to defend the nation by criticizing the procedures that the armed forces have adopted. So there is a problem because the judiciary has become know-all. As I said, collegium system evolved from 1993 onwards, and major milestone for it was the Keshavanand Bharti case, in which in 1973, Supreme Court opined that the basic structure of the Constitution cannot be altered by parliamentary amendments to the Constitution. Now, Constitution itself does not say what is the basic structure. That is an interpretation of the Supreme Court in 1973. So, as I said, in 2014, National Judicial Commission Appointment Commission Act was passed by the Parliament and was ratified, but it was not allowed to be operative. There is not only the conflict between judiciary and executive, there's conflict between judiciary and legislative branch. And first instance of judiciary legislative conflict was in UP Assembly case in 1964, in which UP Assembly that had actually sent to jail somebody for contempt of the Assembly legislature got into conflict with the Allahabad High Court and subsequently Supreme Court, and somehow it was resolved. Crisis was resolved, but it was earliest example of confrontation between judiciary and the legislature. More recently, the example of judiciary legislature conflict is attempt by a Supreme Court bench to tell the additional Solicitor General of India to go and talk to a constitutional functionary that happens to be the Vice President of India, not make adverse comments about Supreme Court. And the Vice President refused to meet with the additional Solicitor General because Vice President thought it was improper on part of the Supreme Court to send the ASG to him. More recently, in various judgments, Supreme Court benches have lamented that the legislature does not make good laws, implying thereby that Supreme Court should have a role in determining what laws should be made and what should not be made. This judicially public conflict, Aam Janta, judiciary is upset with the public about making critical comments on the social media platforms. And the question arises why the judiciary is so thin-skinned. Judiciary wants the executive and the agencies of the executive to prosecute Aam Janta or people for criticizing judiciary on the social media. Andhra Pradesh High Court directed CBI to probe certain NRIs for making some adverse comments on the judges of Andhra Pradesh High Court. And I've given the reference from Deccan Chronicle. There's also an issue of judiciary, allocating itself entitlements and abusing privileges. So there has been creation of post-retirement jobs by the Supreme Court for retired judges, left, right, and center. Why should certain statutory commissions have only retired judges as chairperson? That is a very, pertinent question. But Supreme Court insists that certain statutory commissions will have ex officio chairpersons who are retired judges. Nobody else is qualified to be chairpersons of those commissions. And with that comes abuse of privileges, because once you are appointed chairperson of the commission, you are entitled to a bungalow in Lutyens, Delhi, a car, a secretariat, staff, allowances, and salary. So the most blatant example of abuse of privileges by Justice MMS Liverhan's commission that was initially appointed for 6 months and kept on asking for extensions every 3 months for a period of 18 years. And Justice Liverhan's had a bungalow, car, secretarial staff, and salary for 18 years after his retirement. Then, not only in India, everywhere there are laws to curb freedom of expression. Now, Indian Constitution did allow freedom of expression, but there was a constitutional amendment, the Second Amendment to Constitution of India done by Jawaharlal Nehru government that restricted freedom of expression. At this point in time, there are blasphemy laws in 74 countries, mainly these are OIC members and some Christian countries. There are less majestic law in Thailand by which one can be imprisoned for more than 10 years for saying anything insulting to the king or monarchy. In certain countries, these laws are used against political adversaries by the so-called King's Party, the party of the establishment. Indian law has parallels about blasphemy law. You can be prosecuted for creating enmity between different groups. It's essentially a variant of blasphemy law. But there's also contempt of court doctrine in India, that has chilling effect on academic discussion, highlighting the state of affairs of judiciary. Highlighting corruption in the judiciary, one could be prosecuted for contempt of court, as I'm risking myself to contempt of court. I've been told that if I come to India, I could be prosecuted. So doctrine of the contempt of court, it needs to be defined much more strictly according to some written parameters. They have to be written parameters. Speaking the truth must not be the ground for judicial punishment after invoking the contempt of court doctrine. And that is what is happening at this time. It is a very regressive doctrine. It either must be repealed or scope must be narrowed and restricted. As per Supreme Court judgment, truth is not the defense in contempt of court cases. Even if you speak the truth, that somebody has been corrupt, you can still be prosecuted in jail for contempt of court. I think that is a ludicrous situation. So there is a perception of general bias. In selective cases, bail applications have been taken on telephone by the Supreme Court, especially in cases of Teesta Setalwar. Some of the public interest litigations that are filed by Teesta Setalwar were taken by a particular Supreme Court bench headed by Justice Aftab Alam. This happened in around 2008, 9, 10. And there was a former Justice of Gujarat High Court, S.M. Soni, who also happens to be former Lokayukta of Gujarat, had to write a letter to Chief Justice of India, S.H. Kapadia, to stop this bench practice. In certain issues, court has been taking suo motu cognizance at a very alarming speed. So there's sense of selectiveness and sense of bias. The Supreme Court has also been grandstanding from the pulpit. And we saw that in Nupur Sharma case, oral observations were made by two-judge bench of Justice J.B. Pardiwala and Justice Suryakant when a bail application, anticipatory bail application was made. Essentially, those oral observations seal the life and fate of this particular person. So Supreme Court is actually, by its observations, endangering the life of a citizen of the Union. And that is something very, very abominable. The abuse of the PIL system is by a nexus of lawyers who will approach selective benches of the Supreme Court knowing that they will get favorable verdict. In common parlance, it's called the smell test. And some of these PILs do not pass the smell test. So what are the problems and issues with collegium system? Constitution has been hijacked by the Supreme Court, and these are not my words. These are the words of retired Justice R.S. Sodhi, that Supreme Court has hijacked Indian Constitution by a collegium system. It is opaque and arbitrary. There are no set selective criteria for selection of judges. It encourages nepotism. It is ineffective in weeding out corrupt judges. And what Dr. Agnihotri was talking about, the uncle judge syndrome. Dynastic appointments from judicial dynasties, it is very well talked about. So when people are elevated to High Court and Supreme Court, in the High Courts, around 70% are recruited from the bar and 30% on the judicial services, the state judicial services. When it comes to Supreme Court, it becomes somewhat higher. Around 85% are recruited from the bar and only 15% from the judicial services, because they are, already in the High Court, but predominant are the people who have the background of practicing law as a member of the bar. In one case, Chief Justice Altanas Kabir's tenure his own sister was appointed as a High Court judge. Now you control the collegium. Admittedly, Justice Kabir recused himself, but allowed the candidature of his own sister, who was an advocate. And the allegations come from other members of the judiciary. Then Gujarat High Court Chief Justice Bhaskar Bhattacharya alleged that CJI Altamas Kabir had pushed the candidature of his own sister. And I've given the reference below. His sister at that time was only making 74,000 rupees a year as a practicing attorney, which is peanuts, which is a small bear by any standards. So she was not a flourishing attorney and need not have been elevated. So there is an issue of nepotism there. Then there is question of opacity. You don't know who made the recommendation, why the recommendations were made. So Chief Justice Kapadia in 2010 sent back names of 5 lawyers who were recommended for elevation as judges by Delhi High Court Collegium. These names had been recommended by Delhi High Court Collegium headed by Chief Justice A.P. Shah. In fact, those recommendations were sent just a few days before Justice A.P. Shah was about to retire. And these five lawyers were Abhinav Vashisht, Rajiv Varmani, Anusuya Salwan, Meenakshi Arora, and Maninder Acharya. And there was one district and session judge who was also recommended. Now, Justice Shah, after his retirement, had lamented the fact that Supreme Court had blocked his elevation to Supreme Court from High Court. So there was some tussle going on between Justice Shah and some of the Supreme Court judges. And Justice Kapadia did not, appoint his recommendations. So the question arises, what was the deficiency with those recommendations? Nothing is in public domain. Then there was something unusual happened. There was Supreme Court judges press conference on January 12, 2018. 4 senior judges of the Supreme Court called a press conference. And this happened for the first time in the history of independent India, that Supreme Court judges are coming to the press making allegations. These judges were Justice Chalameshwar, Justice Ranjan Gogoi, Justice Madan Lokur, and Justice Kurian Joseph. And they expressed displeasure against then Chief Justice Deepak Mishra about assignment of cases. And they claimed that junior justices were being assigned cases, bypassing the senior judges. And they said, Chief Justice is only the first among equals, nothing more and nothing less. And they said that they were speaking in the press conference because democracy will not survive if judiciary is not impartial. This is not me saying, this is not a politician saying, this is not the executive saying, this is not the legislature saying, this is Supreme Court judges saying democracy will not survive if the judiciary is not impartial, meaning thereby that judiciary is being partial. They had also written a letter to then Chief Justice 2 months before the press conference, and they said that they didn't get any response from the Chief Justice. So you see, this is a picture of those 4 judges. This is Ranjan Gogoi, and this is Chalameshwar. And there's question of corruption in high judiciary. There have been numerous allegations of corruption in High Court and Supreme Court. In fact, I'm not going to name the name. One legal luminary asserted that half of the Chief Justices of India were corrupt. And this person runs a Center for Public Interest Litigation. And he alleged that there are fixed benches, fixed outcomes, double standards. There's manipulation of rosters. I already talked about the Teesta Setalwad's cases coming before the bench headed by Justice Aftab Alam. Then more recently, last year, 2-3 judges in Supreme Court recused themselves from any case pertaining to West Bengal, because they were afraid that if they sit on those cases, their families will be targeted with the violence ongoing in West Bengal. So that gives you an idea whether the judiciary is fearless or not, or there are other extrajudicial considerations. Allegations of corruption in Supreme Court. I already talked about Chief Justice Altamas Kabir's sister being elevated. But there was another case. There was Chief Justice Y.S. Sabharwal. His tenure was known for direct instructions from Supreme Court to Municipal Commissioner of Delhi to demolish shops in residential area. And during that time, every day, there were raids conducted by Municipal Corporation Commissioner of Delhi to residential colonies where shops were operating. Now, why would Supreme Court of India send instructions to Municipal Commission of Delhi to stop some shops in residential areas of Delhi? It's a minor municipal affair. But later on, we find out there was a conflict of interest. Justice Sabharwal's two sons owned shopping malls in Gurugram. And they were using the home address of CGI to conduct business. I'm not going to say anything more than that. Then there's an issue of Supreme Court judgments backfiring. I am a physician. Dr. Purohit is a physician. If we do something wrong, we are liable. Malpractice suit. Somebody dies, malpractice suit. If a judge takes his decision and it goes south, nobody is held accountable. People are released on bail and they commit murders. Nobody is held accountable. Where is the accountability? So in Bhopal gas tragedy case, Union versus Union Carbide case, Supreme Court of India, led by two Chief Justices, Justice R.S. Pathak and Justice Ahmadi, sold the Indian public for a settlement for 475 million settlement. After retirement, Justice Ahmadi became chairperson of the Bhopal Hospital Trust Fund for Victims. Previous chairperson was a UK lawyer who had abrogated some funds on refurbishing his house and office in London. Now, more recently, there was a PIL for reopening of this case for renegotiating the settlement. And Supreme Court does not want anything to happen. They want to instruct the government of India to pay additional compensation to the victims, not the offending party. Similarly, in Italian Marines case, Enrica Lexi case in 2012, Supreme Court intervened and transferred the case to itself and gave bail to Italian Marines who jumped the bail, left the country, and never came back. And in fact, in this case, finally, Supreme Court closed the criminal proceedings against Italian Marines in 2021 after compensation of 10 crores was paid to the victims' families and owner of the fishing boat and the staff of the fishing boat. But nobody was prosecuted criminally for killing Indian citizens. Essentially, the Indian Supreme Court endorsed the concept of blood money because nobody was criminally prosecuted. You cannot buy the life of a citizen by paying compensation. That is not true of Indian law. That may be true in Middle East, in Islamic countries where concept of blood money is there. But the way Supreme Court interfered in the local case going on and took the authority and gave the bail, I think does not behove of the Supreme Court. Then there's a judiciary political party nexus. A statement has been made in social media and other places, movie world, sarkar kisi ki bhi ho, lekin system to hamara hai. There was a famous saying during Congress regimes, the law will take its own course. And one of the Congress leaders said during Congress party rule, we had a tradition of not enforcing the laws. Now the same party is repeating the mantra, process is the punishment. Again, you see judicial political party nexus. In 2012, there was a famous case of Abhishek Manu Sanghvi, there was a sex video which surfaced, and there were allegations that promises were made for judicial appointment. High Court Justice Abhay Thipse from Bombay High Court, Allahabad High Court, joined the Congress party immediately after retirement, and speaking to Indian Express, Abhay Thipse said, "It is important to fight communal forces and communalism." So it's for people to infer what is going on. There's a revolving door phenomenon between judiciary and political party nexus. So I'll give a case study of Devi Das Thakur. Devi Das Thakur started his law practice in Ramban in Jammu and Kashmir and became a practicing lawyer. After 4 years, he moved to High Court, Jammu and Kashmir High Court. In 1973, he was promoted to the position of judge of the Jammu and Kashmir High Court. In 1975, he was inducted in the state cabinet after he resigned as a High Court judge. He remained Minister for Finance, Planning, Laws, Food, Civil Supplies, and Transport from 1975 to 1982. Then he resigned as cabinet minister and moved to Delhi and started practicing in Supreme Court as a senior advocate. And from 84 to 86, he became again Deputy Chief Commissioner of Jammu and Kashmir. And then after that, he was appointed in 1990 as governor of Assam and Arunachal Pradesh. So, you know, one day you are a High Court judge, next day you are a cabinet minister, then you resign, practice as an advocate. So there is something going on which does not, you know, cover the judiciary with glory. What can we do to improve the current system? The collegium system, which is causing all this tensions. So judiciary has insisted that the government finalize the memorandum of procedure, which government did not do for several years. And more recently, the law minister sent a letter to Chief Justice giving some suggestion how memorandum of procedure can be finalized, suggesting that maybe it should be a two-step process. Step one should be a search cum evaluation committee, where there should be a government nominee that can help with process of search and evaluation. And then step two should be collegium recommendation. So that way collegium will not face any, you know, situation where an inappropriate person is recommended. And then there is suggestion that collegium could receive recommendations from respective chief ministers. That is what law minister's letter said. But why stop at chief minister? Even the speakers of state assemblies, law ministers, the state law ministers, public, law commission, and bar associations could make recommendation to collegium if there's a deserving candidate. The candidate can be evaluated through such an evaluation committee and then recommended. Why would the collegium not want broader feedback about candidates to higher judicial posts? Deliberations of collegium should be made public and transparent and then forwarded to the president. Important is to realize that consultation as stated in the Constitution does not mean concurrence. Generally, we say, physician, heal thyself, and I would say, judiciary, reform thyself. Why I'm saying that? Because recently the Supreme Court Collegium on a particular case made recommendations of Intelligence Bureau and Research and Analysis Wing reports public. These were about a specific recommendation of an advocate from Delhi, Saurabh Kirpal. Now, Saurabh Kirpal has been in line for the last 5 years, and government does not want his candidature for High Court because there are security implications. I'm not going to go into details, but Supreme Court Collegium made all those files open. What about the intelligence personnel who are doing their due diligence? There's oath of secrecy. You know, these were very sensitive observations that were made, and collegium, in order to confront the executive, made these open. What could be the other option? Other option is that legislature can bring another constitutional amendment bill and pass the National Judicial Appointment Commission bill again, taking into consideration the objections that were made by the Supreme Court earlier in invalidating the 2014 amendment. And of course, if a new bill is brought, president could sign a new bill and states could ratify. So you would have a new National Judicial Appointment Commission bill. I think it would behoove the Supreme Court to keep an open mind about any possible new amendment to the Constitution rather than invalidating or holding it in abeyance without even letting it be implemented. And it will be advisable for Supreme Court not to entertain future PILs if another constitutional amendment comes, because they are always interested parties that, will file a PIL. What other judicial reforms can be done? So for state level recruitment, consider an Indian judicial service on the pattern of IAS, IFS, and IRS. States need a buy-in instead of doing state-level competitive examinations. So the competitive exam at the national level could be done by Union Public Service Commission, and candidates could opt for cadre in 3 states in rank order fashion. And ideally, these judicial officers selected through All India Judicial Services should not be posted in state in which they are domiciled because of nexus with local politicians and things like that. Then we have pendency of cases in the Supreme Court. There are 60,000 cases pendent in the Supreme Court. How can we reduce the pendency? Supreme Court wants more judges to be appointed. They were supposed to be 7, now they are 34. Even if you appoint 68, probably the pendency will not go because this is the way Supreme Court is functioning. I personally think that Supreme Court should not entertain any bail applications. They should be left to the lower judiciary and high courts. Supreme Court is the constitutional court. It should not be doing the job of a trial court or a sessions court or something like that. Judiciary at higher level should cancel all vacations in national interest. It may be an entitlement, but you have to do what is good for the nation. Number of working days for the Supreme Court must increase from current 193 days per year. Supreme Court functions only 193 days out of 365. The executive works 365 days a year, 24/7. The bureaucracy works 365 days, 24/7. The doctors work in hospitals 365 days. Hospitals don't go on vacation. Doctors go on vacation, but somebody else is functioning. Increase the length of workday in the Supreme Court. Supreme Court starts working at 10 a.m. and finishes at 2 p.m. Delegate administrative work to non-judges. Why should judges waste precious judicial time doing administration? No more PILs should be entertained by Supreme Court because they are not urgent till the pendency of cases is over. Supreme Court can save time by writing briefer judgments rather than judgments last, thousands of pages. That takes time. And finally, no oral observations while playing to the audience, because that has chilling effect on subsequent course of the justice. So in criminal cases, it's not just the judicial reform, there's need for police reform and investigative agency reform, upgrading of the forensic labs and automatic video recording of each deposition or affidavit, because that leads to, right way, otherwise witnesses turn hostile. I think one way of reducing PILs would be to attach costs for every frivolous PIL. There are PIL mills, and there are certain lawyers who need to have penalty points like if you make a driving error, there's a point on your driver's license. Similarly, there should be something on the attorneys who are filing frivolous PILs. They should be cost attached, and there should be some ethical action by the Bar Association against their law license. There should be automatic penalties and fines if they are filing too many frivolous PILs. And finally, there should be suspension of law license in such cases. In pendency of cases, what is the role of the government? The biggest litigator in India is the government of India. There's never-ending appeal process that has to stop. Mindless appeals by bureaucrats must be curtailed, and settlement of some of the pending cases should be done through arbitration process rather than automatic appeal process. I've already talked about post-retirement appointments. I think they should create some ethical standards that no judicial officer, and more particularly of the higher judiciary, should be assigned any posting in any establishment, including Rajya Sabha, after their retirement. There must be at least 3 years of cooling period. You get your pension benefits, you get all the retirement benefits. You don't need a second job immediately after retirement. So there has to be some cooling off period. And judiciary must not mandate that retired judges alone can be on various tribunals and commissions. Assets and liabilities. All the judges of the Supreme Court, High Court, state judicial officers must mandatorily and publicly disclose their net worth, assets, liabilities annually, including those of their spouses and children. And it must include shareholdings, bank accounts, properties, including Benami properties, foreign bank accounts, gold, jewelry, etc. Let's come to impeachment of judges. So far, no Supreme Court judge has ever been impeached in India. It was attempted only 4 times since 1947. I've listed, actually, I'm not going to go through each case. It was attempted 4 times, but was never successful. The reason is that the process is very cumbersome and slow. It is an ineffective remedy as the system is gamed by the target of the impeachment. You need a motion by 50 members of Rajya Sabha or 100 members of Lok Sabha to even bring a proposal for impeachment. Consent of the Chief Justice of India is a must. So Chief Justice can veto any impeachment proposal. Impeachment needs to be made easier to weed out corrupt judges. Those who resign to obstruct impeachment process should forfeit their retirement benefits. So I'll give you example. Amidst charges of corruption, land grab, and abuse of judicial office, Justice P.D. Divakaran, who was Chief Justice of Sikkim High Court, against whom Rajya Sabha chairman had set up a judicial panel to look into allegations of corruption, resigned in July of 2011 before impeachment proceedings could be initiated against him. By resignation, he saved his retirement benefits and pension. What other judicial reforms can be done? Ministry of Law needs to remove the old colonial statutes from the rule book and introduce new and more appropriately written laws. Include sunset clauses in each new law for review. Law making should be left to the parliamentarian, i.e. legislature, and not to the judges. And there must not be automatic arrest in certain cases, because in Indian situation that is always abused. Let the investigations be done in a time-bound manner in any case. So those are some of the ideas I have collated, and we can have questions and answers now.
How much time we have?
I think we are left with at least 10 minutes for discussion.
10 minutes. You have done such a good job. 10 minutes is not enough for discussion. I'm part of this whole deal. We need to talk more, much more. Do you want to talk more, or just maybe we can meet another day also? The reason is that you have covered so many good things about this whole system. You look like a lawyer to me, than a judge. It's a great thing. Your statements are very well done. And when you were talking, I was thinking about myself. I was in the judiciary for 10 years. I was the youngest judge in the Commonwealth of Nations at the age of 24. And I have seen so many things which was causing me so much anger at all levels, from the Supreme Court down to other justices all the time. It's very difficult for me to say, but I don't mind saying, because I don't mind. I left the system because I was sick and tired of it, to be honest. I felt that everything was nothing but corruption at all levels, except for a few exceptions here and there, that everything was being done in some way. I can tell you one thing. One Supreme Court judge asked me to see him. I went to see him. And he first said that I understand you are very slow in deciding cases. I said, what? I said, my judiciary has given me a privilege to do blah, blah, blah. I was honored for so many things. And also I said, what do you mean by that? I have more. So I said, but there's one case in which you were very slow. I said, which case you were talking about, Your Honor? You know what he said? He said that he mentioned the name of the person. And I was shocked that this judge is asking me that I have delayed the case of one person in my court. And that person was not in my court, by the way. Just a day before, the case was transferred to me. And I said, then I talked to the judge. I said, look, what are you talking about, sir? It's not me. It is some other judges who did it. So then suddenly he said, okay, I mean that you should take more actions. What I'm trying to say, he was ultimately promoting a lady who was in charge of a hospital, and he had some work with her. Can you believe this is the kind of things they were doing? And many other things I can talk. I can give you 20 examples of what was happening in corruption, directly and indirectly. So therefore, I personally feel that what is going on now, it is only a start. The judiciary has to be straightened up. There are some good judges also. I know one judge, as I mentioned to you earlier, who was my supporter. He was a session judge one time, and then he became a high court judge and Supreme Court judge. And he was trembling almost when I saw him one time, because he told me that everybody was after him because he was an honest judge. Honest judge during emergency, I'm talking about. All these things I can talk about and mention to you, but I am happy that we have raised these issues. And of course, I want to mention this to you, that let us meet again maybe and discuss all the issues Dr. Adityan has mentioned beautifully well. I think he has done a good job in that sense, that not being a lawyer, he has acted better than a lawyer, anybody. And I think we should need to talk more about this issue, and please come prepared. I'll talk more and we'll discuss more. Maybe next time we just keep it for that, if you don't mind.
Okay.
We'll do it today for 1 hour.
Sure.
What do you think?
I think that is good.
I think let's talk, because you had done such a good job. You prepared so well. And I think we need to discuss all the elements step by step. And I have a lot of things to talk about also myself. I can give examples to you. I don't want to mention names to you, but I remember names also, by the way. And one reason I left judiciary was this, that 90% people are corrupt. If you are not part of the corruption, then you are in trouble. Corruption means not direct corruption, indirect corruption. Yes, please.
Yeah, this is Hariyar Singh.
Yes, please.
Dr. Adityanji, you have done outstanding job in terms of doing your diagnostic study of this issues, the problem, whatever we call it in the judiciary system in India. And it has been excellent in terms of not only diagnosis, you provided all examples, all cases, all everything nicely. And then you also came up with the solution based upon your understanding, whatever knowledge you have, whatever experience you put everything over there. And just like Dr. Agnotri is talking about, he may add to that one. But let us think about what we can do. We are sitting in United States of America, and very good understanding about the whatever system is going on in Indian judiciary, how this can be reformed, how this can be done, what practically can be done, can be all those solutions what we are coming out after this diagnosis. Is there any concrete way this message can be communicated with those who are in power in India? So I think we all can do, you all can do that. But this is very good thing, something people sitting outside of India thinking that way to improve and add to the system in India, that will be helpful forever to come. So I think it's very outstanding thing started. I think it was excellent, outstanding. And I think just have another meeting so that Dr. Agnotri can add to that. Then let's make all exhaustive review. Again, you did very good review as a scientist, as a physician. You did all, just like if I have to do it, I'll go in depth like that, as you did. Did all diagnostic about this issue, all these problems, and then you are coming up with the solution. And then you are saying, who can do it? So that is another thing. So I think very good. I congratulate you and thank you for bringing up this issue, discuss with us. Thank you.
विवेक जी,
जी, हाँ, yes.
आप ऐसा करिएगा कि एक हमारा मीटिंग 3 हफ्ते के बाद होती है, 2 हफ्ते के बाद होती है?
अरे महीने भर में हो रही है।
आप एक मीटिंग और करिएगा,
ठीक है।
और मेरी रिक्वेस्ट आप सबसे, 11-12 लोग तो यहाँ पे थे इस प्रोग्राम में, बाकी लोग भी होते हैं बाहर जो नहीं आते, बाद में मुझे बताते हैं कि हमने सुना सब कुछ. We will request everybody to come prepared.
Sure.
The very, very nice discussion can start. Dr. Adityan has done a good job, and we should look into every aspect. मैं क्योंकि इन्वॉल्व हूँ इस प्रोसेस में था, अभी तो मुझे ख्याल नहीं, मुझे बहुत याद आ रही जब ये बात कर रहे थे ना. I was remembering so many things about myself, and I'll give my stories to you. A lot of stories I have.
Sure.
And now I'm remembering that story, those I've forgotten about those stories. So we'll talk about the story, how messy the system is. Unbelievable.
Yeah.
Even starting from the process, how many cases person can handle, how many cases person should handle. And as Aditya just said, that they don't work, to be honest. I can tell you examples of so many people, so many justices at the highest level and lower level. This is unbelievable that India is suffering because of this judiciary, to be honest. And I think we cannot charge it because we start the process. And so let us talk one more time.
Sure.
And everybody should come up with something. Okay?
Okay. So next time.
And please give the information to everybody, the people who were ever involved, and mention to them that we had a good discussion. And Adityanji has done he has raised a lot of issues,
Great.
and it has been our decision to meet again and talk further.
Sure. I'll send the next invite
Please,
for the same. Yes. Yes, Sridharji.
because, yeah.
My suggestion that give the 2 week times and make bombard information to not only the among ourselves, but even the outside Americans also, or law students also, or law faculty also. This is a really interesting subject and very well presentation and thought provoking. So this is my suggestion.
Very good. That's
Sure.
right. We are happy about that.
So
Let
we'll-
us talk. Please,
Hmm?
all of you should prepare something on some subject. Don't worry, you're not lawyers, but you can prepare something because everybody messed up, and we will talk about this. And maybe I should get somebody from a local place too, America too, American also, to come and talk. Okay?
Okay, great. So until next time.
And Vivek ji, is this talk going to be on YouTube? If you put immediately on the YouTube, it will be, people can watch again. Those who missed today, they can watch and they can get involved this group
So
also.
I will talk to Rajiv ji because lately we
Right,
have been
sir.
just keeping the.
Sorry to
I
bother
think
you.
Vivek ji,
This idea, excuse me, sir, the idea of YouTube is not a good idea. We don't want to spill the beans all over the world that Indian judiciary is corrupt. It may be corrupt. Let us handle ourselves. It is good, not outsiders. That's my recommendation. Thank you very much.
विवेक जी आदित्यन जी से पूछ लीजिए कि इसको ऐसे ही जाना चाहते हैं, पसंद करेंगे या इसमें एडिटिंग करने के बाद.
So
I think it
Suresh
is
No,
better for him
so
to
Suresh
edit
ji,
it and then put it on online.
Suresh ji, it's a live streaming right now.
I know,
So
I
whole
know,
thing
but
is
it is-
already recorded.
I understand, but it is not on. That can always be manipulated.
Sure,
But
yes.
what you want to provide to others,
Hmm.
exactly the same matter, or you want to edit and then make it available? And that Adityan ji should decide it.
Okay, I'll work with Adityan ji however he likes to do it.
I think this is my suggestion. This is just like a diagnostic study of this problem. So it should not be publicized. We are discussing in a small group over here who are going to put more efforts in furtherance of this, whatever efforts Satyandi had made it. So let's, you can review all those presentation, what has been done today. I don't think it is secret. It is recorded. We get copy of it. Whosoever is interested, go ahead, review it, see what are the ideas. Can you add anything? Can you improve anything? Yeah, is there what? If you have ideas, you can write it in the next meeting. You can present it. Let Dr. Agnoti present his views because he has that background, so he have more items. Once it's done, then you go and see how you are going to narrow it down and what is the important, effective way to communicate with those who are responsible position to do something to that. So that our efforts is not only just a research-based effort, that could be practical also. If we can make our effort, that will be more useful. You don't need to publish at this time because this is premature. I'll say until this maturity is done with everything, then you have a right to publish. Yeah, publish or communicate whosoever is to do it. So this is my opinion. That's it. Thank you.
Again, I would like to say this is a very well presentation.
Yeah.
With whether we like it or not, this suggestion for reform in the judiciary, the critics will use to corner the government for political agenda, to set the narration. This is a good presentation, very calmly presented with the facts and figure, all these things that I have not seen. I'm a journalist, and we, as a journalist, we look for the fault. But I have not found any fault. I learned a lot of new things, and nothing wrong to go. It's not a corruption in India. corruption everywhere, all over the world in democratic country. Dictatorship, we do not know about that. My point is that getting involved with the American University law faculty and students as well as outside is a good way to let them know what is our intention, what we are asking for. Outside is a good way to let them
I think there's an echo from someone, so please mute yourself. You're not talking.
Only thing I can say that it was an excellent presentation, Dr. Purohit. And I think we can we can combine all these things and get a paper out of this one. And that is all the ideas summarized in one paper, and that can be distributed, to the other organization, or, even in India, some of the governor's offices, chief minister offices, or those people can be said that these are our ideas, we are giving the ideas, maybe they can look into that part,
So
Yeah.
I see two things here. One, what Dr. Adityanji has presented, obviously there's a lot of information there. And as Dr. Agnihotri says, we should come prepared, right? So in order for anyone to prepare, you have to look at what he has presented.
Yeah.
I'm not sure how many of us can remember all the points and pick one point which you want to discuss or which is closer to your heart and you want to take it forward. And I think it looks like, Agnihotri, with your permission, that it probably will take a couple of sessions to cover the different topics if that happens. So, and at the end of it, as Dr. Purohit said, we can come up with a paper or something. By that time, we will have all the points captured and we can.
The issue is that at this time, the issue is pending. They are
Yes.
discussing it. By the time we meet next time, there may be some movement already in place. So therefore, we should be along with the movement, what's going on. And then at the same time, we should prepare some sort of, because the people are, the issue has been raised already.
Yes.
Okay. The government has already taken a stand to some extent. They're very scared of it, by the way. The stand was very mild stand. But starting, this is a starting process. Ultimately, it will go further down. Because I think what the government has done at this time, raising questions, and the other people who are just, they thought they were super duper people, they are considering it, what to do. And I think by the time we'll talk, maybe we will talk and we'll get some other people to talk to us. And we may become a little bit more knowledgeable of what is going on. Okay.
Sure. Yes. Okay.
And I think Adityanji has done a good job, and he will also keep track of it, what's going on at this time. Okay.
Okay.
I'll keep track also, because
Sure.
I'm studying everything what's going on, and step by step, I think there will be movement toward doing something, because also the government is very, very careful not to do too many things against or about the Supreme Court. Okay. But there is no way but to set them straight. Okay. As simple as that. Okay.
Okay.
I mean,
So-
nothing against them, but they have to be stirred up a little bit. Okay.
Sure. Okay. So again, thank you everyone for your valuable time. I think it was a eye opener for so many of us, getting this whole picture together by Dr. Adityanji. And as Dr. Agnihotri said, we'll meet next time, and I will send the information. And please do come prepare, have some of your thought process together to talk about, to discuss, or question we can ask Agnihotri or Dr. Adityanji, since he has done some research, more deep research, and take this discussion forward.
Thank you.
Okay, thanks. Good night.
Thank you very much.
Good
Thank
night.
you.
Namaskar.